So good morning class. Today we are doing over the next class regarding the PYQs of a law of contract, and that is the PDF which I already shared to you from my Vrinda Legal Institute Telegram channel. So if you want to be download any kind of notes, sorry for that. If you wanted to be download any kind of notes from Vrinda Legal Solution, then you can be go to the channel of a Vrinda Legal Solution, and where you can get access of all kinds of documents in respect of our notes, one liner, and the PYQs lists. Okay, so now we start over the lectures in respect of that PYQs. First question is about in which section of Partnership Act it is laid down that there can be a partnership in a single or particular business. Particular business partnership are laid down in a section 8. Clear? Every offence and punishable under section 147 under the Negotiable Instrument Act 8081 is compoundable. That is right. All offence under the Negotiable Instrument Act is completely compoundable offences. Under the Partnership Act, under the Partnership Act, a minor who has elected to partnership when attain the majority should adhere to the following. Which one of the following is incorrect? इनमें से कौन सा incorrect है? Issue a public notice that he has elected to become और that he has elected not to become a partner. ये बात ठीक है कि उसे public notice issue करना पड़ेगा. Option must be exercised within the 2 months on attaining majority. That is wrong. So the answer is B. They require the 6-month minimum. Within the 6 month, not if it is the minimum, that is the maximum. Within the 6 month, that minor who become the major now have to be adopt any option, either to be continue with the partner or to not to be continue with the partner. So the answer is B, which are incorrect as per the question. So very केयरफुल विद दैट कि क्वेश्चन ने पूछा क्या है, इनकरेक्ट पूछा है या करेक्ट पूछा है. देन कई बार क्या होता है कि हमें क्वेश्चन पता होता है बट बिकॉज ऑफ ना हरी हमें लगता है कि जो करेक्ट है वो आंसर होगा, तो हम ए को मार्क कर देते फर्स्ट रीड में ही. बट वट वी नीड टू डू, वी नीड टू बी रिकॉग्नाइज कि उसने पूछा क्या, उसने इनकरेक्ट स्टेटमेंट पूछी है. सो द आंसर इज बी. Now we come with the match of the following is that. So simple mutual right and liability are right down in the section 3. Dissolution of partnership in section 39. Retirement of partners is section 32. Clear? And insolvency are right in a section 34. So the answer is 2, 3, 4, 1 and that is B. Simple static questions this is. The surety has no right to restrain execution against him until the creditor exhausted all his remedy against the principal debtor. That is right. Surety cannot be go against the surety cannot be made liable until and unless the creditor take the all remedies against the debtor. That is right. The liability of surety is coextensive with that principal debtor unless it is provided by the contract. That is also be right. So the A and B are correct and B is the correct explanation of it. So the answer is A. Under the Sales of Good Act, to make the buyer liable for neglecting or refusing of delivery of goods, which of the following condition must be fulfilled? Make the buyer liable. If you wanted to make buyer liable, so let me read the which one of the following is incorrect. Again go with that. कौन सा इसमें से गलत है? सो द फर्स्ट ऑप्शन इज द सेलर आर रेडी एंड विलिंग टू डिलीवरी ऑफ द गुड्स. दैट इज राइट. द सेलर आर रिक्वेस्टेड टू बायर टू टेक डिलीवरी. दैट इज आल्सो राइट. अगर ये दो कंडीशन है तो हम बायर को लाइबल कर सकते हैं. द सेलर इन्फॉर्म द बायर टू इग्नोर द डिले एंड टेक डिलीवरी. द सेलर इन्फॉर्म द बायर टू इग्नोर द डिले एंड टेक डिलीवरी. दैट इज इनकरेक्ट. सेलर इज नॉट. सेलर इज ओनली जस्ट टू बी रेडी टू मेक डिलीवरी. The buyer did not within reasonable time after such request take delivery of the goods. So the incorrect portion is that is C. The seller informed the buyer to ignore the delay. Wait. Let me going to be read it again. Under the Sales of Good Act, to make the buyer liable for neglecting and refusing delivery of goods, the following condition must be fulfilled. Which of one of the following given below is incorrect? That is it. तो ये अगर सेलर उसको इन्फॉर्म करके कह रहा है कि अपना सामान ले जा और वो लेने के लिए तैयार है, तब तो वो हम बायर को लाइबल नहीं कर सकते. तो दैट कंडीशन इज अ सी. ऑल कंडीशंस आर बी गुड करेक्ट एज पर दैट सिचुएशन दैट इफ यू वांट टू मेक लाइबल टू द बायर. क्लियर? Which one of the following is not essential requirement to fulfill an instrument intended to be a promissory note? कौन सी essential requirement नहीं है promissory note की? The promissory note must कंटेन प्रॉमिस टू पे, ये तो सही बात है. ए मेयर एक्नॉलेजमेंट ऑफ इनडेप्टनेस इज सफिशिएंट, दैट इज नॉट. द मस्ट बी सर्टेन अमाउंट, अनकंडीशनल और प्रॉमिस टू पे, ये तीन तो इसेंशियल रिक्वायरमेंट है. मेयर एक्नॉलेजमेंट कैन नॉट बी बिकम द प्रॉमिसरी नोट. नेक्स्ट क्वेश्चन इज where a bill is unintentionally cancelled by the holder or his agent and the cancellation is not apparent thereon, the bill is discharged. Holder, that is wrong. Where the bill is unintentionally cancelled by the holder or his agent which are not apparent thereon, that is wrong. This should be apparent on thereon. That is the principle of section 82, that is also be wrong. So the answer is A. Both A, B, A and R are wrong. Next is about the again match the following. Partnership cannot be created by the status, that is the case of Rakesh Kumar Dinesh Kumar versus UG Hotel and Resort Limited. That are the things that only you have the status and respect of firm, it cannot be a partnership. Essential of partnership are always you go with the CTS versus K Kalkutti. Joint family and Hindu family are not in a partnership, that is the case of Ganpat versus Anandji. Partnership between outsider and joint family, that is the case of Kestara Mohan versus commercial of excessive profit tax. So the answer is 3 and 1, then 4 and then 2. 3 1 4 2, let me go. 3 1 4 2 is a, so the answer is A. Next question is about the match the following. Again with the sections, the match the following are there. So first is duty to absolute good. Absolute good is defined in, absolute good faith is defined in section 9. Duty not to compete, that is section 16 subclause B. Due negligence is 12B and 13F, and indemnify from fraud, that is 10. So the answer is 4 1 2 3, that is B. Goods are goods were means every kind of movable property including actionable claim. So no, wait, that is wrong. Excluding are become, goods are never become with the actionable claim. And upper principle 2 7, that is both are the wrong. So both answer is B, both A and R are wrong. Next is again about the in a case match the following is there. So first is remuneration to partner in absence of an agreement on this matter. Remuneration of partner deal with the Salet brothers versus Nanhaf, Harnifal and Salet. Second is fixation of remuneration by agreement in respect of the partner does not alter his status of partner. That is right, that is the Abdul Sadar versus state of Andhra Pradesh. Next is about the interest. Interest on a capital of a partner, that is Bhagchand versus Kaluram Moolchand. Action against a partner for a balance due to another, that is a case of Gisul versus Gambhiril. So the answer is 3 and then 4 3 1 4 and last is 2, 3 1 4 2, that is D. Assertion region question थोड़ा सा इसमें साइड में हो रहा है. I will going to be read for you. Partnership of an erstwhile unregistered partnership firm can bring a suit to enforce the right arising out of the contract within the ambit of section 16. That is wrong. If the partnership firm is not registered, you cannot enforce your right. And that judgment of that case, that is also be wrong. So the both A and R are wrong. Mercantile agent, they ask with the mercantile agent, which is the correct in respect of mercantile agent. Mercantile agent having in a usual course of business such sailor authority, sale goods or to consign goods of the purpose, that is wrong. Having in customary business such as, no, not is like that. Customary codes, having in customary course of business as such agent authority to sell goods, that is C. C is right as the correct definition in respect of a mercantile agent. Yeah, it's right. Next is about the 15 question which asks which one is correct. इनमें से कौन सा correct है. Association of good of sale Association of good for sale is done by buyer. That is wrong. Appropriation of good of sale done by seller. That is also wrong. Distinction between ascertainment of goods and appropriation of good former involve the element of common intention between buyer and seller, whereas later can be unilateral. No can be unilateral. Both are the both are to be bilateral, and both have to be common intention to make. Property in goods does not pass to buyer till appropriation. That is right. Without appropriation, property cannot be transferred from seller to buyer. So only 4 is a correct answer. Which is the following presumption as to negotiable instrument under the section 118 of the Negotiable Instrument Act? Presumption contractual capacity के presumption is right. Consideration तो नहीं थी. Presumption of date जरूर था. So 1 and 4th. So answer is a C. Clear? Last page we come with the today's class. Question is the essence of sale of transfer of goods in property from seller to buyer. The essence of sale in the transfer of goods and property from seller to buyer. Transfer of good. ठीक है, ये बात ठीक है. And section 4 sub plus 1 का it's a simple. Section 4 sub plus 1 की direct statement है. Which one of the following statement are correct? A partner of an unregistered firm can sue as a partner. That is wrong. A unregistered firm can enforce its claims against the third party in civil court. That is also wrong. The chapter named Registration of Firm in Partnership Act is applicable to Hindu trading family. That is, it's applicable to everyone, whatever the Hindu, Muslim, Christian. It's not the any kind of religion matter. Registration of firm is designed primarily to protect the third party, and the essence of registration need not prevent disappearance on unregistered and imperfect registered firm. That is right. So the only 4 is correct, and the question only 4 is correct. Who can be a partner in firm? Who can be a partner in a firm? If you go look, Hindu undivided family cannot be a partner. Waqf already is a trust, so cannot be. Another firm cannot make a partner with the firm. So a trustee can be a partner. A trustee can be a partner of a firm. Only one is right. Which of the following statement is correct? A promissory note or bill of exchange in which time for पेमेंट इज स्पेसिफाइड पेएबल ऑन डिमांड. ये बात तो ठीक है. ये बात पहली चीज तो पहली स्टेटमेंट आपकी ठीक है. इफ द एंडोर्सर साइन हिज नेम ओनली एंडोर्समेंट इज सेट टू द फुल. नो, इट्स नॉट. Only name is not full endorsement. Where an instrument may be construed either as a promissory note or bill of exchange, the holder may at this election treat it as either. No, instrument either can be a bill of exchange or can be a promissory note. It cannot be both. If a amount undertaken or order to be paid is stated differently in figure and word, the amount stated in figure shall be amount undertaken. Oh, that is also wrong. So only the first A statement are right, and that is the correct answer of question number 20. So okay class, today we done the, I think be the last. If there is a possibility and required any class more for PYQs of contract law, then I will do, but otherwise I think today that 2 classes are quite be sufficient. So what you need to do, you need to go with the bare act, notes, one liner and the classes, and then make a practice as much as you can till the exam to achieve a good marks in a commercial laws and a law of contract. Okay then, thank you, keep in touch.